For decades, millions of immigrants believed that the moment they raised their right hand and took the oath of allegiance was the finish line. The paperwork was over. The interviews were over. The waiting was over. Citizenship meant permanence. It meant security. It meant that no matter what political winds blew through Washington, your status as an American could never be questioned again. But in 2026, that assumption is being quietly tested in a way we have not seen in generations. A new piece of legislation moving through Congress, combined with a dramatic shift in immigration enforcement priorities, could make it significantly easier for the government to strip naturalized citizens of their citizenship. Not people at the border, not undocumented arrivals, not visa overstays, people who already became Americans, people who built businesses, bought homes, raised children, and voted in elections believing their immigration journey was permanently behind them. The bill is called the Stop Citizenship Abuse and Misrepresentation Act, or the SCAM Act. Supporters say it simply closes loopholes and protects the integrity of citizenship. Critics warn it could open the door to something far broader, a system where citizenship for naturalized Americans feels conditional rather than permanent. And what makes this moment especially serious is not just what the bill says on paper, but the scale of enforcement already being discussed behind the scenes. Internal targets that could increase denaturalization cases from a handful each year to thousands. Expanded definitions of fraud, a 10-year window after naturalization during which certain actions could trigger proceedings. The question is no longer whether denaturalization exists. It always has. The real question is whether it is about to become common, and if it does, who ends up caught inside that system. By the end of this video, you'll understand not only what's at stake, but also what practical steps, if any, you should be considering. Because before we decide whether citizenship is truly at risk, we need to understand what that promise of citizenship was always supposed to mean in the first place. For generations, American citizenship has been treated as one of the most secure legal statuses in the world. The path to get there is not simple, and anyone who has gone through it knows that. Years as a lawful permanent resident, background checks that examine your history in detail, fingerprints, interviews, English testing, civics exams, travel records, employment history, tax compliance, and finally, standing in a federal courtroom or government building, raising your right hand, and swearing allegiance to the United States. That moment is not symbolic fluff. It represents finality. It represents acceptance. It represents the understanding that you are no longer temporary, no longer conditional, no longer in between. You are American. That promise of permanence has shaped entire lives. Naturalized citizens have built businesses, bought homes, joined the military, run for office, and raised children with the confidence that their legal identity in this country is stable. A U.S. passport is more than a travel document. It is proof that the uncertainty is over. Families pass that reassurance down to the next generation. Once you become a citizen, no one can take that away from you. And importantly, that belief has not just been cultural, it has been legal. The strength of American citizenship was deliberately constructed that way. Lawmakers understood that if naturalized citizenship could be easily revoked, it would undermine the entire purpose of naturalization itself. So they built guardrails. They created a system where denaturalization, the legal process of revoking someone's citizenship, was designed to be rare, difficult, and reserved for extreme circumstances. Not administrative sloppiness, not minor errors, not misunderstandings on complex forms completed years earlier in a second language. Extreme circumstances. Under current federal law, the government can pursue denaturalization, primarily if citizenship was illegally procured or obtained through concealment of a material fact or willful misrepresentation during the naturalization process. That timing matters enormously. The alleged fraud must have occurred at the time the person applied for and obtained citizenship. Prosecutors must prove that the individual intentionally lied or deliberately hid information that would have disqualified them. And the burden of proof is not casual. It is high. The government must present clear, convincing, and unequivocal evidence. Courts have repeatedly emphasized that stripping someone of citizenship is one of the most severe actions the government can take, and therefore it cannot be based on suspicion, minor inconsistencies, or innocent mistakes. There is a fundamental legal distinction between someone who knowingly falsified a material fact to gain citizenship and someone who misunderstood a complicated question, forgot a short trip abroad from years earlier, or made a clerical error on paperwork. For decades, that distinction protected millions of immigrants who navigated a complex immigration system in good faith. That is why denaturalization cases historically have been extraordinarily rare. In a country of more than 330 million people with roughly 26 million naturalized citizens, the average number of denaturalization cases filed annually over much of the past decade has hovered around only a handful each year, often cited in the range of about 15 cases. Those cases typically involved egregious fraud, war crimes, terrorism-related concealment, or serious national security threats. In other words, the system functioned as intended, as a narrow safety valve for extreme misconduct tied directly to the citizenship process itself. And here's the crucial point that many people misunderstand. Under the current framework, committing a crime after you become a citizen does not automatically jeopardize your citizenship. If a naturalized citizen commits an aggravated felony years later, they can be prosecuted, imprisoned, fined, and punished under criminal law like anyone else. But their citizenship is not normally revoked simply because of post-naturalization conduct. The logic behind that framework is straightforward. Once you are fully admitted into the political community as a citizen, your status is no longer tied to ongoing behavioral conditions in the way a visa holder status might be. Citizenship marks the end of that conditional relationship. The only time post-naturalization conduct becomes relevant under current law is if it reveals that the person lied during the original application. For example, if someone concealed membership in a terrorist organization when applying and that deception is later uncovered, denaturalization can occur because the fraud happened during the naturalization process. Timing is everything. The law has drawn a bright line at that moment of oath. That bright line is precisely what the Scam Act proposes to blur, because once the government is no longer limited to misconduct that occurred during the naturalization process, the scope of who could potentially face scrutiny expands dramatically, and that is where the debate in 2026 begins to intensify. The Stop Citizenship Abuse and Misrepresentation Act did not appear out of nowhere. It was introduced in January 2026 by Senator Eric Schmidt in the Senate and Representative Tom Emmer in the House at a time when immigration enforcement had already become one of the central priorities of the administration. Supporters framed the bill as a targeted reform designed to close what they describe as dangerous loopholes in existing denaturalization law. They pointed to several highly publicized fraud investigations, including a large-scale benefits fraud case in Minnesota involving members of the Somali immigrant community, where some of the individuals accused of wrongdoing had already become naturalized U.S. citizens by the time the alleged fraud was uncovered. Under current law, prosecutors face significant limitations in those types of cases because the misconduct occurred after citizenship was granted. Unless the government can prove that the individual lied during the naturalization process itself, citizenship generally remains intact. To supporters of the Scam Act, that limitation represents a structural weakness. They argue that if someone commits serious fraud against the United States government, even years after naturalization, the law should not shield them from losing citizenship simply because enough time has passed. In their view, citizenship is not just a status, it is a privilege that must be protected from abuse. The bill, they say, restores integrity to a system that has been too narrow and too hesitant to act. But here is where the proposal begins to move beyond simply closing a loophole. The Scam Act does not make a small technical adjustment. It restructures the foundation of when and why citizenship can be revoked. The first major change is the expansion of fraud grounds. Instead of limiting denaturalization to fraud committed during the naturalization process, the bill explicitly includes material fraud committed against the United States government at any point. That phrase sounds precise, but in practice it is broad. It could include benefits fraud, tax fraud, immigration petition fraud on behalf of family members, or other forms of deception involving federal agencies. Under this framework, a naturalized citizen who commits qualifying fraud years after becoming American could face not only criminal penalties, but also a separate civil action to revoke their citizenship. That is a fundamental departure from the bright timing line that has existed for decades. The second major change involves aggravated felonies. Immigration law defines aggravated felonies as a category of serious offenses that includes crimes such as murder, rape, sexual abuse of a minor, drug trafficking, firearms trafficking, certain large-scale fraud offenses, and more. Today, if a naturalized citizen is convicted of an aggravated felony after naturalization, they face criminal punishment like anyone else, but their citizenship remains intact. Under the Scam Act, conviction of an aggravated felony would become a standalone ground for denaturalization. That means the conviction itself could trigger proceedings to strip citizenship, even if the crime had nothing to do with the naturalization process. For supporters, this ensures that individuals who commit the most serious crimes do not continue to benefit from U.S. citizenship. For critics, it transforms citizenship from a permanent status into something that can be revoked based on conduct long after the oath was taken. The third set of changes focuses on national security and organized crime. The bill expands language related to affiliation with terrorist organizations, espionage, foreign intelligence activities on behalf of hostile governments, and participation in transnational criminal enterprises. Some of these grounds already exist in narrower form under current law, particularly when tied to concealment during naturalization. The Scam Act would codify and broaden them more explicitly, potentially allowing denaturalization even when the connection to the original naturalization application is less direct. The debate here centers on interpretation. What counts as affiliation? How direct must the involvement be? In highly charged political climates, definitions can stretch, and that elasticity is what concerns many civil liberties advocates. Another controversial element of the bill addresses evidence standards. Supporters describe it as a clarification designed to make enforcement more practical, allowing prosecutors to rely on a broader range of documentary and circumstantial evidence. Critics worry that this language could effectively lower the evidentiary threshold in real-world application, making it easier to pursue cases based on inconsistencies in old files or ambiguous records rather than clear proof of intentional deception. Because denaturalization is a civil proceeding, not a criminal one, the burden of proof, while still high, does not require proof beyond a reasonable doubt. Any shift in how evidence is evaluated therefore carries serious consequences. Finally, the Scam Act introduces a 10-year statute of limitations tied to certain post-naturalization conduct. If a qualifying offense occurs within 10 years of becoming a citizen, the government would have the authority to initiate denaturalization proceedings. Historically, the longer someone remained a citizen without issue, the more secure their status was presumed to be. This provision reframes that assumption. For the first decade after naturalization, certain actions could reopen what many believed was permanently closed. Taken together, these changes represent the most significant proposed expansion of denaturalization authority in modern American history. And if this breakdown is helping you clearly understand what is actually written into the bill, consider subscribing so you stay updated as it moves through Congress. Immigration law evolves quickly, especially in 2026, and clarity matters more than ever. But legislation on paper is only half of the story, because at the very same time this bill is being debated, enforcement priorities inside federal agencies are already shifting in ways that could dramatically amplify its impact. Even before the Scam Act has passed, something significant is already happening inside the enforcement machinery. For years, denaturalization existed mostly in theory for the vast majority of Americans. It was technically possible, but rarely used. Historical averages often hovered around a dozen or so cases annually nationwide. In a country with roughly 26 million naturalized citizens, that number was almost statistically invisible. It reinforced the idea that denaturalization was an extraordinary remedy reserved for the most extreme situations. war crimes, terrorism concealment, egregious fraud directly tied to the citizenship application itself. But in 2026, reports from immigration attorneys and former agency officials suggest that internal priorities have shifted. Field offices within U.S. Citizenship and Immigration Services have reportedly been encouraged to review old naturalization files more proactively and refer potential cases to the Department of Justice. Instead of passively responding to tips or discoveries, officers are being asked to look. According to multiple legal observers, internal targets discussed within the system aim to generate somewhere between 100 and 200 denaturalization referrals per month. If those numbers hold, that could mean more than 2,000 cases annually, nearly a hundredfold increase compared to historical averages. Even without the Scam Act, that scale alone would represent a fundamental change in how denaturalization is treated. What was once rare would become routine, and when bureaucracies operate under numerical expectations, even informal ones, incentives shift. Officers begin searching for cases rather than waiting for them. Ambiguities receive closer scrutiny. Borderline situations move forward instead of being dismissed. That does not automatically mean wrongdoing or abuse, but it does change the atmosphere. A system designed for exceptional cases starts functioning like a regular enforcement pipeline. Now layer the Scam Act on top of that environment. Expanded fraud grounds, aggravated felonies as standalone triggers, a 10-year window for post-naturalization conduct, broader evidentiary flexibility. Suddenly, the universe of potentially reviewable cases grows significantly. A file that would have been closed under the old framework might now raise questions. A conviction that once had no impact on citizenship might now initiate a civil action to revoke it. And once a case is referred to the Department of Justice, the process is not quick or simple. Denaturalization cases can take years to resolve. Legal fees can reach tens of thousands of dollars. Families live under prolonged uncertainty. Even if the individual ultimately prevails and retains citizenship, the emotional and financial strain can be enormous. For many, the fear is not just the possibility of losing citizenship. It is the fear of being pulled into a system that feels overwhelming and unpredictable. So, who realistically could be affected? Supporters of the Scam Act argue that the answer is straightforward. Serious criminals, fraudsters, and individuals who should never have obtained citizenship in the first place. They emphasize that law-abiding naturalized citizens have nothing to worry about. From that perspective, the bill targets only bad actors who abused the system or committed major offenses. But critics caution that the line between serious misconduct and material fraud can be more subjective than it appears. The term material is not self-defining. It requires interpretation. Does a misreported income figure on a benefits form count? What about an omission that was later corrected administratively? What level of involvement constitutes affiliation with a prohibited organization? These determinations are made case by case, often influenced by prosecutorial discretion and prevailing enforcement priorities. Another factor is timing. Because the Scam Act reaches post-naturalization conduct, individuals who obtained citizenship honestly and legally could still face scrutiny based on actions years later. Imagine someone who became a citizen 8 years ago and 3 years after naturalizing made a serious error on a federal benefits application. Perhaps it resulted in repayment and a penalty at the time. Under the proposed framework, that incident could be reclassified as material fraud within the 10-year window, opening the door to denaturalization proceedings. Even if the person ultimately demonstrates lack of intent to deceive, the mere initiation of the case changes everything. There is also concern about unequal enforcement. History shows that enforcement patterns can concentrate disproportionately on certain communities, whether due to political attention, media coverage, or investigative focus. If file reviews intensify in particular regions or among specific immigrant populations, the statistical impact may not be evenly distributed. The law itself may be written in neutral language, but its application can vary depending on priorities set by leadership and agencies. And then there is the scale question. With approximately 26 million naturalized citizens in the United States, even a tiny fraction facing scrutiny translates into significant numbers. If 0.1% were ever investigated under expanded criteria, that would represent tens of thousands of individuals and families. For most people, citizenship has been synonymous with closure, the sense that the immigration chapter of their life is complete. A dramatic rise in denaturalization activity challenges that psychological certainty. It introduces the possibility that files can be reopened, that past conduct can be reassessed, that the line once thought permanent may now feel conditional. And as this debate intensifies in Congress and within federal agencies, the question becomes not just whether the Scam Act will pass, but how profoundly it could reshape the meaning of naturalized citizenship in America. To really understand how this could unfold, it helps to move away from abstract language and look at realistic scenarios, not extreme hypotheticals, not sensational headlines, just ordinary life events that under a broader denaturalization framework could take on new legal weight. Imagine someone who immigrated to the United States 25 years ago, became a lawful permanent resident, worked steadily, paid taxes, and eventually naturalized 12 years ago. 3 years after becoming a citizen, they applied for a federal benefit during a period of financial hardship. On the application, they misreported income, perhaps misunderstanding how certain earnings should be calculated. The discrepancy was later identified. The agency required repayment and assessed a penalty. The issue was resolved administratively and life moved on. Under the current traditional framework, that incident would not reopen their citizenship because it did not involve deception during the naturalization process itself. But under the Scam Act's expanded language, if that conduct falls within the 10-year post-naturalization window and is characterized as material fraud against the government, it could form the basis for a denaturalization referral. That does not mean citizenship would automatically be revoked, but it means a federal civil lawsuit could begin. Legal representation would become essential. Court proceedings could stretch on for years. Even if the person ultimately prevails by proving a lack of intent, the stability they once felt would be shaken. Consider a second example. A naturalized citizen is convicted of an aggravated felony 5 years after becoming American. Perhaps it is a serious drug trafficking offense or a large-scale fraud conviction involving more than $10,000. Under current law, that conviction leads to prison, probation, fines, and a permanent criminal record. But citizenship remains intact because the offense occurred after naturalization. Under the Scam Act, that same conviction could serve as a standalone trigger for denaturalization. The person could complete their sentence, begin rebuilding their life, and then face a separate federal action seeking to strip citizenship and potentially remove them from the country entirely. For individuals who left their country of origin decades ago, who built families and communities here, that possibility carries enormous emotional weight. There is also a quieter category of cases that worry many immigration attorneys. Old files with inconsistencies. Naturalization applications can be lengthy and complex. Travel histories spanning years must be listed with precision. Employment timelines must align. Names and dates must be consistent across multiple forms filed over decades. Minor discrepancies can occur for innocent reasons, translation issues, memory gaps, clerical errors under a high evidentiary threshold focus strictly on willful misrepresentation during the naturalization process. Those inconsistencies rarely rise to the level required for denaturalization. But if evidentiary standards are broadened in practice, and if officers are proactively reviewing thousands of files annually, ambiguous records may receive greater scrutiny than ever before. Most will likely go nowhere, some may not. And when the government initiates a case, the burden shifts to the individual to defend their citizenship in federal court. This is where the larger philosophical debate emerges. Supporters of the Scam Act argue that none of these scenarios should concern law-abiding citizens. In their view, citizenship is a privilege that must be earned honestly and upheld through responsible conduct. They contend that if someone commits serious fraud or egregious crimes, particularly within the first decade after naturalization, the government should not be powerless to act. To them, the bill reinforces accountability and protects the integrity of the system for everyone who followed the rules. Critics see something more structural. They warn that expanding denaturalization grounds risks creating a two-tier concept of citizenship. One tier for those born in the United States whose citizenship cannot be revoked except in the most extraordinary constitutional circumstances, and another tier for naturalized citizens whose status could be revisited based on post-naturalization conduct or evolving interpretations of material fraud. The concern is not only about individual cases, it is about precedent. Once citizenship becomes more conditional for one group of Americans, the symbolic permanence of naturalization begins to erode. There is also the question of proportionality. Criminal law already provides mechanisms to punish fraud, drug trafficking, violent offenses, and other serious crimes. Sentences are imposed, fines are paid, probation is completed. Critics ask whether adding the potential loss of citizenship on top of those penalties creates a consequence that exceeds the original offense, especially when citizenship represents identity, belonging, and constitutional protection. Supporters respond that certain acts are so severe that they justify that additional consequence. The disagreement ultimately turns on values. Is citizenship primarily a permanent membership in the national community once granted, or is it a status that remains contingent on conduct for a defined period after naturalization? As this debate unfolds in Congress and across the country, millions of naturalized Americans are watching closely. For some, the bill feels like a necessary correction. They are common sense. The first practical step is staying informed from reliable sources. Immigration policy moves quickly, especially in an election cycle and especially in 2026. Rumors spread faster than legislation. Social media posts often exaggerate timelines or misinterpret legal language. Make sure you are following reputable legal analysts, established news outlets, and immigration law organizations that provide updates grounded in actual statutory text rather than speculation. Understanding what the bill actually says, rather than what headlines imply, reduces unnecessary fear and helps you respond rationally if changes occur. Second, preserve your records. If you still have copies of your immigration history, your green card documentation, your naturalization certificate, prior visa paperwork, and any correspondence with USCIS or other federal agencies, keep them organized and accessible. If you filed benefits applications, tax returns, or other federal forms over the years, maintaining copies can be invaluable. Most people never need to revisit these documents after naturalizing. But in an environment where old files may receive renewed attention, having your own complete record provides clarity and protection. Third, reflect honestly on your naturalization application. Were there complex issues, extended travel abroad, name variations, gaps in employment history? If something in your past immigration process felt confusing at the time, consulting with an experienced immigration attorney for a file review can provide reassurance or guidance. This does not mean hiring a lawyer preemptively out of fear. It means recognizing that early clarity is far less stressful than reacting to a government notice without preparation. Fourth, approach international travel thoughtfully if you have a complicated legal history. As we move deeper into 2026, the fate of the Scam Act will depend on congressional votes, political calculations, and public pressure. But regardless of its outcome, this moment highlights something important. Citizenship is not just a document. It is a legal status, yes, but it is also a shared national understanding. It is the foundation upon which people build their lives, careers, and families. Any change to how secure that foundation feels will ripple outward in ways that statistics alone cannot measure. If you are a naturalized citizen, remember this: you earned your citizenship under the laws that existed at the time. That achievement remains real. No proposed bill changes the fact that you completed the process lawfully and took the oath in good faith. What is being debated now is how future conduct and expanded definitions should interact with that status. Staying informed ensures that you are part of that conversation rather than reacting to it after the fact. If you found this breakdown helpful, make sure you're subscribed and turn on notifications so you don't miss updates as this legislation develops. I'll continue tracking the bill, any amendments, enforcement data, and court responses so you can understand not just the headlines but the actual implications. Share this video with anyone who naturalized within the past decade or who may have questions about how these changes could affect them. Clear information is one of the most powerful tools we have in uncertain times. The meaning of American citizenship has always evolved alongside the country itself. The question now is how it will evolve in 2026 and beyond. Stay informed, stay prepared, and I'll see you in the next update.